This video is made for educational purposes only and cannot be taken as legal advice.
In this video, I will explain the hierarchy of the court system and what a judicial precedent is and why they are so important. Please also remember knowledge is power.
Hierarchy of the courts and judicial precedent. The doctrine of judicial precedent is based on stare decisis. That is the standing by of previous decisions. Once a point of law has been decided in a particular case, that law must be applied in all future cases containing the same material facts. For example, in the case of Donahue v. Stevenson, 1932, the House of Lords held that a manufacturer owed a duty of care to the ultimate consumer of the product. This set a binding precedent which was followed in Grant v. Australian Knitting Mills, 1936. Also in Shaw v. DPP, 1962, the House of Lords held that a crime of conspiracy to corrupt public morals existed. This was followed in Nuller v. DPP, 1973. In order for the doctrine of judicial precedent to work, it is necessary to be able to determine what a point of law is. In the course of delivering a judgment, the judge will set out their reasons for reaching a decision. The reasons which are necessary for them to reach their decision amount to the ratio decidendi of the case. The ratio decidendi forms the legal principle which is a binding precedent, meaning it must be followed in future cases containing the same material facts. It is important to separate the ratio decidendi from the obiter dicta. The obiter dicta is things stated in the course of a judgment which are not necessary for the decision. For example, in R v. Howe and Bannister, 1987, the House of Lords held that the defense of duress was not available to murder. This was the ratio decidendi of the case. The House of Lords went on to consider whether the defense should be available to those who attempt murder and stated obiter dicta that the defense of duress should not be available to attempted murder. In addition to binding precedents, there exists persuasive precedents. These consist of judicial statements which are not binding but may be taken into account. For example, the obiter dicta from R v. Howe and Bannister was followed by the House of Lords in R v. Gotts, 1992, which held that the defense of duress was not available to attempted murder. A form of persuasive precedent is obiter dicta. Persuasive precedents also include case law from other jurisdictions, and traditionally the Privy Council decisions have been merely persuasive on the English courts. However, exceptionally the Privy Council may be binding. As in the case of Attorney General for Jersey v. Holly, 2005. Hierarchy of the courts. There exists a hierarchy of the courts. The basic rule is that a court must follow the precedents from a higher court, but they are not bound to follow decisions from courts lower in the hierarchy. A basic outline of the hierarchy is: 1. European Court of Justice. 2. Supreme Court, formerly House of Lords. 3. Court of Appeal. 4. Divisional Courts. All other courts, county, crown, magistrates, tribunals, these have no power to create precedents. Where the precedent was set by a court of the same level, the court is generally bound by the previous decision, but this is subject to exceptions. Different considerations apply, depending on the level of court, as to whether the court may depart from a previous decision of a court of the same level. European Court of Justice. The European Court of Justice does not recognize the doctrine of precedent and is free to depart from its own previous decisions. Decisions from the ECJ are binding on all courts in England and Wales. House of Lords Supreme Court. The House of Lords was replaced by the Supreme Court from the 1st of October 2009. The Supreme Court will exercise the same jurisdiction as the House of Lords, and the Law Lords will take office as justices of the Supreme Court. At one time the House of Lords were absolutely bound by their own previous decisions. However, in 1966 the Lord Chancellor, Lord Gardner, issued a practice statement allowing the House of Lords to depart from a previous decision where it appears right to do so. Whilst the House of Lords had this power, they were reluctant to use it. and refused to overrule controversial cases. In considering whether to use the 1966 practice statement, the House of Lords needs to be mindful of the retrospective effect of their decisions. In Cunningham, 1982, the House of Lords refused to overrule the previous decision of R. v. Vickers, 1957. Because of the retrospective effect it would have on those convicted of murder and had been subject to the death penalty. Court of Appeal. The Court of Appeal is bound by judgments from the ECJ, the House of Lords and Supreme Court. It is generally bound by its own previous decisions, however this is subject to the exceptions set out in Young v. Bristol Aeroplane, 1944. However, greater flexibility is afforded to the Criminal Division of the Court of Appeal. Lord Denning was critical of the constraint operating on the Court of Appeal and wished to have the same power to depart as enjoyed by the House of Lords. He attempted to evade the rule in Young v. Bristol Aeroplane in the Court of Appeal in Davis v. Johnson. However, on appeal to the House of Lords, the Lords were critical of Denning's approach and affirmed that the 1966 practice statement was for the exclusive use of the House of Lords. Divisional Courts, of the High Court. The divisional courts are bound by the ECJ, Supreme Court, House of Lords, and Court of Appeal. They are also bound by their own previous decisions subject to the same exceptions set out in Young v. Bristol Aeroplane Co. Limited, 1944. Ways of avoiding precedent. Judges may avoid following a previous precedent by overruling, reversing, distinguishing, overruling. This is where a court higher in the hierarchy departs from a decision made in a lower court. The previous decision is no longer binding. This can also occur in a court of the same level in the circumstances I have already discussed. Reversing. This is where a higher court departs from the decision of the lower court on appeal. Distinguishing. This is where the facts of the case are deemed sufficiently different so that the previous case is no longer binding. Declaratory theory of lawmaking. According to William Blackstone, judges do not create or change laws. They simply discover and declare what the law has always been. This means that case law operates retrospectively since the law as declared has always existed.